Our second case this morning is 2019-1274, Ohioans for Concealed Carry et al. Versus the City of Columbus, Attorney Zach Klein et al. For the appellant, Mr. Kessler.
Thank you, Chief Justice, and good morning. May it please the court, I am Dave Kessler. I'm here representing Ohioans for Concealed Carry, the Buckeye Firearms Foundation, and Mr. Gary Witt in this matter. Madam Chief Justice, I'd like to reserve 3 minutes for rebuttal, if I may. In 2006, the General Assembly passed Ohio's statewide firearm preemption statute, revised code section 9.68. That law, as the court knows, prohibits cities from enacting laws that burden the right of the people to keep and bear arms. In short, cities, beginning with the effective date in March of 2007, lost the ability to decide who can have a gun or what guns they can have. Unfortunately, as the court well knows, Columbus and other cities have, since the law was enacted, ignored it and passed firearm regulations that are prohibited by 9.68 on several occasions. This case involves Columbus's most recent attempt. But the issue in this case, I think it's important to focus on, is that statewide uniformity. It's no exaggeration to say that statewide uniformity is the most important piece of firearm legislation in the state of Ohio. Without it, even the right to carry a concealed firearm becomes meaningless. The last I looked, there are 247 cities in the state of Ohio. If each one of them were to pass its own firearm regulations, the right to carry a gun outside the home would quickly evaporate, and it just couldn't be done with any peace of mind. In fact, that was the state of affairs prior to the enactment of 9.68. So this case is not about specific firearms or parts of firearms. It's not about whether people convicted of an offense that the city currently considers to be domestic violence should have a gun. It's about statewide uniformity. It's about the promise that the General Assembly made to gun owners in 2006 that they needn't care what cities think about their right to keep and bear arms. They only need to be familiar with Ohio and federal law. In this case, we have two issues. They both involve associational standing. As the court knows, an association has standing to sue on behalf of its members when one, a member would otherwise have standing. Two, the issue is germane to the purpose of the organization. And three, neither the claim nor the relief sought requires the participation by individual members of the association. Now, in this case, the 10th District admitted that statutory standing under 733.59 may undergird associational standing and satisfy the first element. But it then went on to say that because neither association in this case was an actual taxpayer, that they didn't have associational standing, which to me was very circuitous and a non sequitur. In this case, both associations have standing because element number one is met. It's the law of the case that the trial court and the Court of Appeals both found that Mr. Witt has standing as a taxpayer. So element number one is met, and that's the law of the case. We have a member with standing. Unmentioned by the Court of Appeals in that regard was that it wasn't just Mr. Witt who sent a demand to the city attorney that he institute an action for injunction. Both associations did as well on behalf of their members in the city of Columbus that are taxpayers. So far more people than just Mr. Witt triggered statutory taxpayer standing.
Well, Mr. Kessler, were any of those people named?
They were not, Justice.
So how is that satisfactory if, like is evident with Mr. Witt, there's a name, there's a known taxpayer?
I think if you look, I'm not sure that it requires a name. If in fact statutory taxpayer standing can be the basis for associational standing, what difference would we need to list, for example, every member who happens to be a taxpayer, or is it sufficient to just list one?
There is. So Mr. Witt is a member of both associations, both organizations?
Mr. Witt is a member of Ohioans for Concealed Carry. But if you look at paragraph 11 of the complaint, it avers, and in fact, I think attached to the complaint are the letters sent by the associations and the facts of the case indicate that both associations have members that are taxpayers of the city of Columbus. I'm not sure that it's necessary or even advisable to name them specifically in the case. I don't even know that we actually needed to name Mr. Witt as an individual plaintiff. So I understand your point, but I'm not sure it matters in this case.
Okay.
Second, the second element of associational standing is that the case is germane to the purpose of the associations. Now, the city, amusingly, in my opinion, tries to convince the court that it has no idea what these associations are about, even given their long history of suing to enforce the firearms rights of Ohio citizens. And that's all laid out in our brief, and I won't repeat it here, but suffice it to say that the court can absolutely look at the positions taken by these organizations in the case of Ohioans for Concealed Carry before this very court on this issue, and in the case of Buckeye Firearms Foundation in other courts, which we have cited, and the court is free to take judicial notice of that. And element three, participation by individual members is not necessary, is almost, I would think it's always going to be met in a taxpayer standing case, because a taxpayer standing case has to seek to enforce a public right, not a private interest. So participation by individual members in a taxpayer case is almost never going to be necessary. I can't think of a case where it would be necessary. So if you ask me, all three elements of associational standing are met here from a taxpayer standpoint.
Counsel, but you agree that your organizations are not taxpayers?
Correct, Your Honor.
Okay.
So I don't think that they need, otherwise the position would be that associational standing can never be founded upon statutory taxpayer standing. And I haven't found a single case that says that. The 10th District didn't cite a case that says that. And I'll remind the court that in Fisher versus Cleveland, this court heard a taxpayer standing case asserted by IAFF on behalf of its taxpayer members. So it's been tacitly understood for a number of years that statutory taxpayer standing can give rise to associational standing. The other issue in the case is the declaratory judgment action, and there's a standing issue there as well. And our position is that the issue in the case is statewide uniformity, that any gun owner in the state of Ohio would have standing to bring a declaratory judgment action against the city to invalidate its unconstitutional ordinances. The harm suffered by gun owners is that the General Assembly said we don't need to know what the law is in any of the 247 cities. Columbus has undone that. We are all harmed in the same way by that, and that is enough for standing. In a declaratory judgment action, really what the court is looking for, as I understand it, is that you want to have an actual case. You want it to be real, not speculative, and I think that that's the case here. It's not speculative.
Mr. Custer, excuse me. It seemed that one of the things that the Court of Appeals was suggesting was that the complaint wasn't specific enough, that it didn't have specific claims of harm. How do you respond to that? And are there certain things in the complaint that you would point us to that in your view show a specific harm to your members?
Thank you, Justice French. I think that the city focuses on the wrong thing. What they want to convince you to do is to hold that what we would need to do is say that either the associations or their members want to have a firearm part that the city banned, or that one of them has been convicted of a misdemeanor that the city has classified as an offense of domestic violence. We say that's not true. The harm is the destruction of statewide preemption. We would have brought this case if the city had banned lime green polka dotted guns, or banned albino men over 7 feet tall from having guns. The harm done by the city is the destruction of the promise of uniformity across the state of Ohio. It doesn't matter to us what exactly they banned. And I don't think it should matter to the court. This court did a good job, I thought, in Ohioans for Concealed Carry versus Clyde of examining how important statewide uniformity was to the General Assembly, and has proven to be for firearm owners throughout the state of Ohio. So when one city is tries to develop cracks in that statewide uniformity, gun owners are harmed, regardless of whether they're affected by the actual restriction put into place by the city. So I think that we have an actual case or controversy. If declaratory judgment is appropriate, I think if you look at the People's Rights Organization versus Columbus case, another Columbus firearms case, you saw that the court, as many courts have, has said that, look, when there's an unconstitutional statute and a party wants to bring a facial challenge to it, particularly where it's a criminal statute or ordinance in this case, filing a declaratory judgment action prior to anybody being prosecuted for it is absolutely appropriate. And we think that's the case here. If there are no further questions, I don't have anything further to add.
Thank you. Mr. Coughlin-Lees?
Sorry, Your Honor, I was having trouble unmuting. Good morning, Your Honors, and may it please the court, Rich Coughlin-Lees on behalf of the City of Columbus. Your Honors should affirm the 10th District for two reasons. First, as it relates to the plaintiff's claim on bump stock ban, that claim has been mooted. And second, the plaintiffs have failed to show that they have standing. As a result, this court should affirm the 10th District. After the federal government banned bump stocks, classified them as machine guns, the City of Columbus repealed its bump stock ban. That has mooted this case out. There is no live controversy whatsoever between the parties in this case as it relates to that ordinance. The city ended up filing just recently its statement of additional authorities relied upon, and that was the New York State Rifle and Pistol Association versus the City of New York. The facts of that case are very similar to this. In that case, the United States Supreme Court decided to hear a challenge to a New York City ordinance on Second Amendment grounds, not statutory grounds like the plaintiffs bring, but on Second Amendment grounds. While that case was in the court, the city repealed their ordinance. The United States Supreme Court found unanimously that that mooted the plaintiff's claim. Your Honors, we believe that the same is true here. As it relates to the bump stock ban, because the city has repealed its ordinance, that claim is moot. With that said, I'm going to, unless there are questions, I will move on to the second area, the lack of standing. It's interesting, Your Honors, that the plaintiff spent most of his arguments talking about the merits. We're not here on the merits. We're here simply to determine whether or not the various plaintiffs have standing. This is not a statutory argument under 968. This is absolutely not a constitutional argument under the Second Amendment. It is simply a question of, have the plaintiffs in their complaint said enough to bring a case?
Mr. Coughlin, I wonder if you could start with where I left off with Mr. Kessler, and that is if you look at the Declaratory Judgment Act and whether they've established a standing under the act.
Your Honor, they absolutely have not. This is no different than what this court said both in preterm Cleveland and in Progress, Ohio, where an organization in Progress, Ohio decided that it was philosophically opposed to the Jobs Ohio program and brought a case. This court was very clear that simple philosophical opposition is not sufficient. You actually have to have skin in the game, so to speak, in order to be able to bring a claim. These plaintiffs simply allege, in fact, the individual plaintiff in this case does not even allege he owns a firearm. We've got two organizations that allege that they are simply made up of people who own firearms. That doesn't tell us anything at all about how they are particularly affected by the Columbus ordinance at issue. we had a situation where a plaintiff says, for example, I have been previously convicted of a misdemeanor domestic violence, and even though it would be contrary to federal law, I want to go out and buy a gun and bring it to the city of Columbus, then arguably that individual might have standing.
Was there an attempt to amend the complaint?
There was not, Your Honor, and I think that actually raises a very interesting issue, because at the same time OFCC was bringing this claim in Columbus, they were bringing a separate claim in Cincinnati. And the Court of Appeals did a very good job comparing the complaint that the plaintiff brought in Columbus with the complaint the plaintiff brought in Cincinnati, where they were.
But that, why would that impact our analysis that they filed a separate complaint in a different case?
Because as the 10th District said, they were much more detailed about people owning specific types of firearms and wanting to purchase specific types of firearms and keep them in the city of Cincinnati. In this case, they just say, I'm an individual plaintiff, I'm a member of this organization, and people who belong to these organizations own guns. Your Honor, that's true of just about every organization in the country. Based on this complaint, we can't tell if this is an organization that has Shannon Watts as the president of the organization, an avowed gun owner who is active in seeking gun reform. So in order for us to be able to tell whether this organization actually has an interest in this case, they need to move beyond simply this. What this court said, I believe, in preterm really focuses. What this court did in preterm was to take a look at an abortion provider who alleged that various provisions of the state budget bill violated the state's single subject constitutional guarantee. And as it related to the written transfer agreement, preterm set out an affidavit where it alleged it altered its business practices because of the written transfer agreement, that it had increased costs because of the written transfer agreement. This court said that's not sufficient. The budget bill had the heartbeat bill in it.
So Counselor, why doesn't having Mr. Witt as a party in this case cure the deficiencies noted in preterm?
Your Honor, Mr. Witt doesn't allege he owns a gun. So if he doesn't own a gun, at a bare minimum, I would say he would have to allege he owns a gun in order to have standing.
Well, why is that when the challenge is to certain aspects of being able to own a gun or apparatus, an apparatus to a gun?
Your Honor, I think this comes into play with what the Supreme Court said in the second provision of the budget bill in preterm, where there was a criminal penalty for doctors who did not check for a heartbeat before they performed an abortion. And what this court said was, well, because preterm itself is not directly subject to criminal prosecution under the budget bill, preterm does not have standing. And oh, by the way, there were no doctors here who were there, and there's still not enough in that complaint for us to determine standing. Your Honor, I have tried very hard to come up with a way for this case to say standing and preterm to say no standing, and at least intellectually, I can't come up with a way where we would have standing for gun groups with a bare bones complaint, but no standing for an abortion provider based on what this court has said in preterm.
Counsel, to agree with you, do we need to overrule Fisher v. Cleveland from 2006?
I don't believe so, Your Honor. I think what we're dealing with here is a very specific term with specifically what standing, what has the plaintiff alleged? Is there sufficient allegations? My recollection on Fisher v. Cleveland was that there were still a little bit better allegations in the complaint than there are here. And Your Honor, I may be remembering that wrong, but that is my recollection.
And you think that the lower court's decision that Mr. Witt has standing doesn't allow associational standing?
That is correct, Your Honor, especially as it relates to the taxpayer action, which was the only standing that the lower court found. And it's important for this court to remember that in Ohioans for Concealed Carry versus Cleveland in the 8th District, the 8th District found that an association cannot bring a taxpayer action, that they were not considered to be a taxpayer. So I think what we've got here across the board is simply, if Mr. Witt had standing, Mr. Witt does have standing as it relates to the taxpayer action, but that alone, the 10th District has said no DJ standing for anybody and no independent standing under 968. Again, similar to what the court said in the Progress Ohio case. So what we are dealing with is directly no injury that anybody has suffered, anybody has alleged. The only thing that we've got is somebody saying, I'm a member of an organization. I sent a letter to the city attorney. That's it. What we have to keep in mind is, Your Honors, if we open the courts to complaints where parties simply are not alleging an actual injury, we're going to allow people to bring suit over anything. If I am, sitting in quarantine and deciding that I just need to find some hobby to do, and I start looking at my insurance policies and say, this clause of my underinsured, uninsured motorist coverage doesn't quite look fair. Maybe I should try and determine whether or not, in fact, I've got coverage under the policy, even though I haven't been involved in an auto accident that was somebody else's fault. I can't go into court to bring that claim. There's no standing, there's no harm. It's purely speculative. That's where we are here. And so, Your Honors, for these reasons, I would ask that the court affirm the decision of the 10th District. And unless there are any other questions, Your Honors, we would stand on our brief.
Thank you. Mr. Kessler, you reserve 4.5 minutes.
Thank you, Chief Justice. I'd first like to address the mootness issue. It simply strains credulity to believe that the city repealed its rate of fire ordinance just because one of the parts that the city banned was administratively determined by ATF to be unlawful without further license. The city's ordinance banned many parts, specifically named parts and a catch-all clause for any other part that might make a gun easier to fire faster than without that part. So I cannot believe that the city repealed its entire ordinance just because one part, a bump stock, was banned by the ATF.
Counsel, what difference does that make?
Well, a party asserting mootness has the burden to demonstrate to the court that, in fact, the case is not capable of repetition. It can't be reasonably anticipated to repeat. That burden's on the city. Given the fact that the ordinance wasn't repealed until this court accepted jurisdiction on our petition, and given the fact that its ordinance went far beyond mere bump stocks, I find that hard to believe. And I think that—
Did the ATF ever revise their determination or their administrative order?
As I understand it, Chief Justice, there was no new regulation, no new statute. They simply changed their mind about the interpretation of the statute.
So, but that's still in effect.
It is. It is, so far as I know.
That still would be guidance or more than guidance for any legislation put forth by the city.
Yes, it would be wise for the city to consider what the federal law is. In fact, in our position is the city should rely on federal and state law rather than creating its own law, because that's what the General Assembly commanded.
So did the city repeal or not?
The city repealed one of the ordinances, the rate of fire ordinance, Your Honor.
But did not appeal the other ban? Didn't repeal in its entirety?
Yeah, it didn't repeal the weapons under disability ordinance, Your Honor. So we still have that in the case. And of course, with respect to both ordinances, we still have the mandatory attorney's fees that are provided by 9.68. That wasn't decided by the trial court before it got up to the Court of Appeals. So the case isn't moot. First of all, I don't believe that the city of Columbus is done trying to destroy statewide uniformity. Secondly, we have the attorney's fee issue. And thirdly, we have the weapons under disability ordinance to deal with.
Mr. Kessler, I wonder if we could focus in on that attorney fees issue. Even if we were to say that part of the case had become moot, everything that has gone on before has still gone on before. It wouldn't, tell me why you believe that that would moot out your claim for attorney fees. Could you not still claim that you were a prevailing party for at least part of the case?
Well, Your Honor, I'm not sure I quite understand your question, but I think what you're saying is just because they repealed the ordinance, we still prevailed.
I think that would be your argument. So forgive my lack of clarity. I'm just having trouble seeing how, even if part of the case became moot because of the city's action, why that would preclude your argument that you're still you still prevailed in at least a portion of your case.
Yeah, Your Honor, I don't have a clear answer for you. We faced sort of that same issue in Ohioans for concealed carry versus the city of Oberlin. There, of course, the city repealed before we got a final judgment, but the Court of Appeals reversed and sent it back saying the case was not moot. There's still that attorney fee issue. It's mandatory under the statute. It must be decided.
Thank you.
I'd also like to point out that my friend, Mr. Coglianese, may have inadvertently misstated the facts of New York State Rifle and Pistol. There, the city didn't repeal its ordinance. It amended the ordinance to do exactly what the plaintiffs in that case wanted. It was the exact amendment that the plaintiffs desired in their ad damnum clause. And the case wasn't dismissed. It was remanded for further proceedings and possibly an amended complaint in that case. That's my understanding of it anyway. And finally, if I can have just 1 second, I want to point out that the preterm case is not helpful here. There wasn't an association plaintiff in that case. It was simply the wrong plaintiff, just like in Hills and Dales. It's a wrong plaintiff problem. And Jobs Ohio, there was no taxpayer standing argument, no claim for declaratory judgment. And I don't think there was an association standing issue in that case either. There was just an organization. I don't know.
Counsel, did you have any other vehicle besides revised code 733.59, the taxpayer suit here?
I'm sorry.
Did you have any other means or vehicle to bring this to the to challenge other than this taxpayer suit?
The declaratory judgment statute, Your Honor.
Okay. So if we find that there is no taxpayer standing, what does that do to your Declaratory Judgment Act?
I think it stands on its own, Chief Justice. I think that these associations and Mr. Witt have standing to sue for declaratory judgment because, like I said, they are harmed by the destruction of statewide uniformity. It has nothing to do with what the city banned or
but
who.
There's no specificity to your argument about harm here.
Your Honor, I think that's the point I'm trying to make, is that the harm is we now have to care what the city of Columbus thinks about who can have guns. And the General Assembly said we needn't care about the city of Columbus or any of the other 246 cities in this state. Just know state law and federal law as a gun owner and you're okay. If that's destroyed, regardless of what they did.
Why not? You have lots of members. I'm sure there's members in Columbus. There may be members other places that want to travel to Columbus. You know, why not file a complaint with a specific member who alleges that they want to own a weapon with one of these parts, and they are being chilled from doing so because of the ordinance. That seems very easy to do. It would even easy to file an amended complaint saying that, and then there wouldn't be a question.
Thank you, Your Honor. I think that would be difficult in this case for the simple fact that there is no way to fire ordinance anymore. So if the case goes back, which it will, one way or another, if the case goes back to the trial court, amending the complaint to allege that somebody has a rate of fire acceleration device won't really matter in this case anymore.
I get that at this point. What about someone with a misdemeanor? There's got to be lots of people out there with a misdemeanor who'd like to have a gun in Columbus.
Well, that might be more difficult, Your Honor. There's right now not a lot of daylight between the city's weapons under disability ordinance and federal law concerning those with misdemeanor convictions of domestic violence. There is some, but it basically involves possession of a firearm that did not move in interstate commerce. So that's probably a pretty small subset of gun owners that have a gun that didn't come from out of state, right? It's because that's what the federal law bans are guns that moved in interstate commerce. So we have several gun manufacturers in Ohio. I suppose we could find somebody maybe that bought one of those guns and has a misdemeanor conviction that the city thinks constitutes domestic violence. But I don't really think we have to go to that length, Your Honor, because the harm is cities are out of this business. And that's the harm, and it's a harm suffered by all gun owners. If we have to now know what Columbus and Cincinnati and Cleveland and Toledo and Dayton, what all of them think about who can have guns.
Thank you. Thank you, gentlemen. We'll take the matter under advisement. You'll be notified of our decision.